but that's history 20 years ago. And because of our fear of losing out, Singaporeans have also developed an interest to have choices. We always like to have choice, to have many options. In case we choose the wrong option, we have an alternative. And therefore, Singaporeans love buffet, and we're back to food. It's very hard to run away from that, especially lunch coming up. But the buffet system in Singapore, whether as a business of F&B, food and beverage, or as a mindset, is something that anyone visiting Singapore will recognize. And also, because we're such a small country, we're always looking at internationalization, being of a higher profile in the world, as well as attracting things from around the world into Singapore, investment, and so on. So having given you sort of a taste of how the Singapore culture is like, I will move on a little bit into the meat of the discussion. So again, Singapore's very strong influence from the British has led to our various intellectual property statutes that are largely inspired by British laws. So the Trademarks Act, Patents Act, Registered Designs Act, Copyright Act, Plant Varieties Act, and Geographical Indications Act are largely British-centric in its origins, but it's changed significantly in various ways, which I don't have the time to go into, but perhaps when there's time after this session, we can always have private discussions. Our court system itself is similar in a sense, but with its own quirks. We have state courts, which is divided into magistrate courts and district courts depending on the jurisdictions. The magistrate courts have, of course, less jurisdiction than the district courts. And the Supreme Court itself sits over the state courts, and this is divided into the High Court and the Court of Appeal. And there's always a general power to grant search warrants. But this is the criminal court system. The civil court system follows using the same entities. So the state courts itself comprises the magistrate courts, the district courts, and also for civil purposes, a small claims tribunal. There are other aspects of the state courts I'm not referring to here because it's not really relevant for IP concerns. But you will see that it's all jurisdictional based on the amount of award that can be given or the dispute that arises in terms of value, money value. The Supreme Court itself, again, is the High Court and the Court of Appeal. Oops. So, with the court system aside, we have administrative proceedings as well. Administrative proceedings exist at the registry level. The Intellectual Property Office of Singapore is responsible for managing the registries for patents and trademarks and registered designs. As in most established IP jurisdictions in the world, there are opposition proceedings available, not for patent applications though. And cancellation proceedings, which is a generalization of words like revocation, invalidation. Yeah? We also have administrative proceedings through our customs department, which are border control measures that they implement. There are two forms of border enforcement available in Singapore. One is initiation by the IP owner. So they'll file a notice in an interest to seize goods that are being imported into Singapore. There's also an ex officio action that can be taken by our customs officials to detain even goods in transit. Okay, I realize I have about 2 minutes left on the clock, but I think I have a little bit more time than that if you don't mind. So the first instance process in the courts in Singapore are like India, so I won't go into detail. So I'll move into arbitration. Having seen how the court structure is very similar to the Indian situation, arbitration itself might be something interesting to highlight too. Ganesh has been, I think, a staff of the arbitration center in Singapore, so he would have inside stories to tell you that might interest you. But on my part, I I will share that the Singapore arbitration system is a reflection of the ancestral model law, and it has been quite successful, at least for Singapore, establishing itself as an international arbitration center, a venue for, I think it's been several decades now. But one of the interesting things that might come to mind whenever we consider arbitration as a project, as a concern, is it does not go through the courts. It is something brokered by an external individual, a private individual who is an expert usually, but he pronounces a decision over a dispute. So the question is, can such an individual pronounce a decision over IP rights? And some of these issues were highlighted earlier by the previous speaker, Stephanie, in the context of mediation. Can a private individual pronounce that a right, an IP right, has been infringed? How is validity to be dealt with by a private individual when validity is something that has to be reflected on the register by striking out of a registered right? So these are interesting concerns which I don't have answers for you today due to the lack of time and due to the opportunity for discussion, but I'll just leave it and plant a thought in your mind. Mediation, I won't belabor the point since it's already been discussed in great detail by the previous speaker, but there are many mediations and options in Singapore. There is private mediation where two parties looking into entering into a mediated negotiation could appoint anyone to preside and help sort the case out. I've been involved in private mediation for some years. Private mediation is a lot more lucrative than a mediation by a center because there are no fixed fees. The Singapore Mediation Center has been very effective and successful in generating negotiated settlements through mediation. It's been around for many, many years. I have the pleasure of presiding as a mediator there for the better of the last 15 years. And it's interesting that I'm seeing more and more IP disputes appearing at mediation at the Singapore Mediation Center. And so what is even more interesting is WIPO has set up a mediation center in Singapore as well. Well, rather, it is an arbitration and mediation center. As most of you are aware, WIPO has established a panel of experts or a panel of neutrals. And this panel is an international panel, but in terms of a venue for dispute resolution, whether by way of arbitration or mediation, it needs to have a site. So WIPO has its site in Geneva, but it has also established a good office in Singapore for the better part of the last 10 years, staffed by a good group of people, and they are now very active in dealing with arbitration and mediation of disputes in Singapore. There's also court-instituted and registry-instituted mediation. When disputes come before these bodies, they will usually try to channel the parties to mediation in the hope of resolving their disputes more quickly. An interesting thing about the registry-instituted mediation is it's now a partnership with WIPO. So if there are oppositions or non-use revocation proceedings in the Intellectual Property Office of Singapore, there will always be an opportunity to refer the parties to WIPO. In fact, it's standard procedure that parties will be referred for mediation. I hear a clink, so I'll rush a little bit faster. This is just a slide on fees, so you can see that it's relatively cheap both ways. Now, before I close, I'd like to refer a little bit to the international aspect of the Singapore activities. As you're aware, Singapore is a party to the New York Convention, so whatever the arbitration awards come out of Singapore or through the SIAC would be enforceable worldwide in other member states. I'm going to skip this and move on to something interesting, which is called the Singapore International Commercial Court. This was set up last year. So it's now come to an one-year anniversary. It was set up with an intention to bridge the gap between court proceedings and arbitration. How does that work? It is an extension of the Supreme Court of Singapore, so it is equivalent to what a high court in Singapore could pronounce, and its decisions are appealable to our Court of Appeal. But what is interesting as well is the judges who are on the bench of the International Commercial Court are not the local judges alone. These are internationally recognized experts, and there are at least 2 IP experts there who can preside over IP disputes. As some of you might be familiar with Simon Bawley and Robin Jacob. And the only requirement for jurisdiction over disputes before the SICC is matters of an international and commercial nature. So IP disputes generally don't have a problem with this. And the parties, of course, must agree to the jurisdiction of this. So in a sense, it's like arbitration, it's like mediation, yeah. But there is an agreement that parties will submit themselves to the jurisdiction of the SICC. But the only thing it is clearly unwilling to decide on are matters involving a prerogative order. For the purposes of the audience's understanding, a prerogative order is an order that has that is directed at a government body. So the SICC cannot order, for example, invalidation of an IP right, because it will be enforceable against a registry. An interesting thing is the court can also choose not to hear the case. Now, it's distinct from arbitration because it allows the joinder of related parties. So in arbitration, you can't do that except by agreement. But once 2 parties submit to the SICC, the rules of court may provide for joinder. This is my last slide. So it is also able to enjoy the Supreme Court infrastructure that exists in Singapore. So issues of translation, issues of court records, of venue, of having a good administrative system, they're all non-issues because the courts in Singapore are very well organized. The result of an SICC award is a court order. So it can be enforceable as a court order. And the jurisprudence of the legal system in Singapore can be applied, or internationally the parties can agree on what law to apply. And there is an appellate process that goes to the Court of Appeal. It is distinct from a conventional court proceeding in that you can actually appoint foreign counsel to lead a case. You can involve foreign judges or foreigners as judges. The scope of IP issues are generally quite wide, except for invalidation or issues that impact on an IP registry. Now the question is enforceability. So it is a court order. It can be enforced in the Singapore as a court order of Singapore. But how does it apply as a court order in other jurisdictions? It doesn't. So that's one weakness of the system. However, there's an interesting development, and some of you might be aware of the Hague Convention. For IP practitioners, it is not that Hague Convention that you're aware of, with the Geneva Act and so on, for designs. This is a Hague Convention that was for the recognition of choice of courts that was signed in 2005. It was initiated, I think, by the US, if I'm not wrong, but the European Union recently ratified it last year. Singapore is now a member, the US is a member, and Mexico. The result of that is anybody under that, who is a national of that system, that treaty system, who chooses one of the country's courts for resolution of a dispute, immediately results in the other countries having to stay their proceedings so that the proceedings in that choice can proceed. It also has the effect that is similar to the New York Convention that some of you might be familiar with for arbitral awards. So an award by one of the member states' court system is effectively enforceable in the other systems. So there is an arbitration effect here as well. So with that, the only thing I would like to finally say is, well, India's a curry, Singapore's a melting pot. We're trying to make curries, but we're also trying to make sashimi, sake, chicken rice, and chili crab. So hopefully the buffet of options available in Singapore will make it a lot more interesting to see how IP develops in our part of the world in the next coming years. Thank you.